Hey, y'all, it's David with I'm So Offended, and this is a continuation of the child support documents here. And this one here is a rule to show cause. The other one was a contempt hearing, and this is a rule to show cause. They're all the same thing, but different words. But as always, I'm not a lawyer. I don't practice law. I don't have any legal experience. Um, everything is everything I say here is for informational and educational purposes only. I'm not liable for anything that you do. All right. So here is this is from South Carolina, right? This is personally appeared before me as duly sworn. When somebody is sworn, it's an affidavit, clerk's affidavit, custodian support records, child support order entered, arrears, and it says CSES case is being scheduled for a rule to show cause hearing because at least one obligation is delinquent if the non-custodial parent has more than one obligation. In this CSES case, both obligations will be addressed at the hearing listed below, along with payments. Okay, and so there's a notary, his signature, and the name of this document is a rule to show cause. So it is therefore ordered that you appear in the family court, and it says where and time. Be prepared to show cause, if any, why you should not be adjudged in a contempt proceeding for civil disobedience. All right. Be advised, I underline this, be advised that your ability to pay is a critical issue in this contempt proceeding. Okay. What do you do if you get one of these? All right, let's just look it up. South Carolina, right? What is the name of this document? It's a rule to show cause. And this is from family court. Okay, let's look it up. South Carolina, rule to show cause. And one of the things they mentioned here was be advised that your ability to pay is a critical issue. Okay, cool. I put that in, hit search in the Google, and there it is. And that's how we get here. All right. So, there you go. Show you what I put in. I just Googled that. And there's the first one. All right. Rule to show cause for contempt of court basically outlines the procedure, the process, how this is all supposed to take place. Issuance of rule to show cause for contempt of court shall be issued by a family court judge, except as rules 24 and 27. The rules to show cause shall be signed by the issuing judge by the date of it, but the date of issuance shall require the responding party to appear in court as clearly stated. Time and date to show cause by the responding party should not be held in contempt, and why permissible relief requested by the moving party should not be granted. All right, so there it is. It says the date, time, issuing judge, clerk of the court. Okay, they follow the rules. Or follow the rules, okay? Affidavit or verified petition, which shall satisfy, it says the supporting affidavit or verified petition shall identify the court order, decree, or judgment which the responding party has alleged violated specific acts or omissions to which constitute contempt and the specific relief for which moving party is seeking. Okay, so they just needed to follow the rules in order for this proceeding to happen. The notice shall be served in a manner prescribed herein, no later than 10 days, okay? Proof of service, okay? Jurisdiction, right? They're establishing jurisdiction. What happened, time and place, service, all of that. They're following the rules. Okay. Return. If at the contempt proceeding the responding party intends to seek counsel, fees, and costs or other appropriate relief permitted by law, then he shall serve a return to the rule to show cause prior to the commencement of the hearing. Unless a family court judge requires a return to be served at some time. All right. So just outlining things that how to carry on this process. Okay. Hearing procedure. All right. So now we're at the hearing. The contempt hearing shall be an evidentiary hearing with testimony pursuant to the rules of evidence, except as modified by the family court rules at the contempt modified family court rules. At the contempt hearing, the moving party must establish a prima facie case of willful contempt by showing the existence of the order of which the moving party seeks enforcement and the facts showing the respondent's noncompliance. The moving party shall satisfy the burden of proof required by law for the specific nature of the contempt before the court. Once the moving party establishes a prima facie case, the respondent is entitled to present evidence of a defense or inability to comply with the order. If requested, the court may allow reply testimony. The court may impose sanctions provided by law upon proper showing and finding of willful contempt, and may award other appropriate relief properly requested by a party to the proceeding. All right, so we're at the hearing. It says the moving party must establish a prima facie case of willful contempt. And what are they showing? The existing of the order. So that's just going to show the order, right? The child support order. And then the fact showing the non-compliance, which is them saying they haven't received any payments and no payments have been made, and they show some kind of statement or bills or whatever as far as like them, saying that this is the amount that is owed, right? The moving party shall satisfy the burden of proof required by law for the specific nature of contempt of court. Once the moving party establishes a prima facie case, which prima facie is just an allegation, the respondent is entitled to present evidence of a defense or inability to comply with the order. Okay, all right, so down here it just says the Supreme Court case law as far as what is civil contempt and criminal contempt, and how the burden of proof at the contempt hearing, and the burden of proof shifts to the respondent to establish his defense and inability to comply with the order. This is Supreme Court law. And that's pretty much it, right? Compensatory damages to a moving party, because they're basically saying that us having to sue you for you not following the court order, like we can get those fees too. Right, so not only are they coming after you for child support and threatening you for child support, to incarcerate you for child support, but you're going to pay for them having to sue you for not paying. So this says a whole lot as to how they're allowed to do what they're going to do and the rules and procedures about what they're going to do and the sanctions they could issue against you and what they can do to you. But the only thing that matters to you is this here, where it says, once the moving party establishes a prima facie case, so once they make their allegations, the respondent is entitled to present evidence of a defense or inability to comply with the order. What would be evidence of a defense? Because they already allege you to be guilty. You're already guilty. You're there because they're saying you failed to comply with the order. Like, that's why you're there, right? You're already guilty. So, doesn't matter what kind of evidence you present, because if you present evidence that you have money, then that means it was willful. If you present evidence that you don't have enough money to pay, it was willful. Because having money, even if it's a little bit, is the ability to pay. Okay? Now, if they don't prove the ability to pay, then they cannot proceed. Okay? They have to prove that it was willful. And it gives you your defense. So let's say you receive this document, rule to show cause. How do you respond? Right? You could go in there, challenge jurisdiction, special appearance. They don't care about any of that. You could go in and do it, but they don't care about any of that. We're going to do it regardless, because the reason why we do it is for the purposes of an appeal, for the purposes of they have to prove their case, right? They have to prove that they have power over you, right? But you use all defenses, and this was an analogy that I used before, right? Think about it in football, where they have numerous plays where they're going to come at you. So do you have only one defensive play? No, you don't. You have numerous shifting and motions that you can do, right, in your defense. So you tell them, I'm here by special appearance. I don't consent to this proceeding. And you don't say anything. You put down in your paperwork that you don't have the ability to pay. And then at the hearing, I do not consent to these proceedings. I don't have the ability to pay. I'm not interested in any of this. And then you just keep your mouth shut. All you had to do is say it once. You're not interested in anything else. According to their rules, in your responding document, you can say, Rule 14, rule to show cause, part part G. So in your response, you could say, according to rule to show cause 14G, and then you quote, once the moving party establishes a prima facie case, the respondent is entitled to present evidence or defense of a defense or inability to comply with the order. The respondent does not have the ability to comply with the order. Wherefore, I move that this court dismiss this matter. Signed. Done. All of the rules that they invoke to come after you, whether it be child support, whether it be family court, whether you're getting sued, all of them have an offensive and a defensive. They all say how the rule and procedure, how the whole process is supposed to be carried out, and it says what the moving party is supposed to do, and defenses. And there is your defense. You got to quote it in the paperwork. You got to put it in your paperwork, because you have no rights if you don't invoke them. And I've shown you in my documents and the things that I've gone through, the things that they file against me, even though it was past the time, even though they were not allowed to file it, even though it was improper. It doesn't matter. If you don't invoke your rights, if you don't point out that they're not following the rules, if you don't point out your defense according to the rule, they're just going to ignore you, issue that body attachment, and do whatever they want. All right, so hit me up on my email, leave some comments, you know what I'm saying? This is South Carolina, and then we previously looked at Florida. I think the next one I'll show is a California one, and yeah. All right, so good luck.